If you're planning to apply for permanent residency, 2026 has brought some of the most significant policy shifts in decades. The days of treating green card applications as standard administrative routines are over. From discretionary evaluations of domestic filings to hard time limits on student visas, major changes across federal agencies mean every applicant needs a strategic game plan. In this video, we'll break down the essential green card policy updates you must know to protect your path to permanent residence. The single biggest shift came on May 21, 2026, when USCIS issued Policy Memorandum PM 602-0199. For years, applicants living in the United States on valid non-immigrant visas could expect Form I-485 Adjustment of Status to be approved almost automatically once all technical eligibility requirements were met. This new policy reclassifies adjustment of status as an extraordinary discretionary benefit rather than a routine entitlement. In practice, meeting technical eligibility is no longer enough on its own. Adjudicating officers now weigh positive and negative factors to decide whether an applicant deserves a favorable exercise of discretion. Dual intent visa holders, like those on H-1B or L-1 status, retain statutory protections, but USCIS has signaled that even maintaining dual intent status isn't an automatic guarantee. To succeed under this heightened scrutiny, applicants must affirmatively build a strong record of positive equities, such as community ties, tax compliance, and long-term economic contributions, right when submitting their initial filing. For international students and exchange visitors, another major structural shift is now underway. The Department of Homeland Security finalized a rule officially eliminating the long-standing duration of status policy for F1, J1, and I visa holders. Historically, students can remain in the country as long as they maintain full-time enrollment and an active SEVIS record. Under the new rule, student admissions are capped at a strict maximum of 4 years, or just 2 years for language training programs. If your degree takes longer, or you transition through OPT while awaiting PERM or H-1B processing, you must now proactively file formal extensions or stay with USCIS before your 4-year clock runs out. With employment-based green card wait times taking several years, managing this hard timeline is critical to avoiding unintended status gaps. On the employment front, the Department of Labor has initiated a comprehensive modernization of the PERM labor certification process. As outlined in the DOL's Spring 2026 regulatory agenda, the agency is updating recruitment standards to align with modern hiring practices, while simultaneously tightening rules around U.S. worker protections and layoff reviews. Additionally, proposed updates to prevailing wage thresholds could significantly raise minimum salary requirements across all 4 wage levels for PERM and H-1B filings. These shifting dynamics come at a time when demand for employment visas remains extremely high. The H-1B cap for fiscal year 2027 reached its limit ahead of schedule, prompting many professionals to look beyond traditional employer lotteries. Pathways that bypass both PERM and the lottery, such as the EB-1A Extraordinary Ability category, EB-2 National Interest Waivers, and E-2 Investor Visas, are seeing a surge in filings as candidates seek more direct routes to permanent residency. Meanwhile, financial scrutiny continues to tighten under stricter public charge standards. Form I-485 applicants and consular interviewees must demonstrate clear financial self-sufficiency. Maintaining organized, well-documented financial records, including tax transcript, employment verification, and asset documentation, is no longer just standard paperwork. It is a vital part of satisfying USCIS's discretionary review. If you're considering consular processing abroad as an alternate to domestic adjustment, keep in mind that embassy timelines and regional processing pauses vary widely. Depending on your home country, visa availability, travel advisories, and local consular backlogs can make consular processing complex. Processing times across USCIS officers currently average anywhere from 15 to over 30 months for Form I-485. Family-based petitions generally move faster, taking 8 to 18 months, whereas employment-based green cards for applicants born in high-demand countries like India and China face substantial backlog delays. Navigating U.S. immigration in 2026 requires preparation, precision, and proactive strategy, because immigration laws, agency memos, and policy interpretations change rapidly. Every case carries unique factors that must be individually evaluated. Please note that this presentation is strictly for general information and educational purposes only, and does not constitute formal legal advice. If you're preparing an application or evaluating your options, consult directly with an experienced, qualified immigration attorney who can analyze your specific situation and guide you through today's evolving legal landscape.